Hey guys, welcome to another episode of DarshanTalks. This week we're going to discuss misleading ads by pregnancy clinics. Can a non-misleading statement be disparaging? Legal implications for doctors and nurse titles. The milk debate. Oat milk versus dairy milk. SlimFast. Claims at court or resolve them at the BBB NAD level. Dark patterns in marketing. Ad compliance in the US versus in the EU. Rebecca Tushnet is our guest. She's a Harvard Law School professor specializing in copyright, trademark, and advertising law. And I am Darshan Kulkarni, principal attorney at the Kulkarni Law Firm. I focus my attention on FDA-regulated companies and their service providers, including issues involving medical affairs, clinical research, and drug advertising. Let's get into it. Rebecca, you mentioned this case on Yelp advertising or sort of marking. Rebecca, certain organizations that claim to have pregnancy clinics as misleading. Could you talk a little bit about that, what the implications are? If you like this type of content, please like, subscribe, share. It really helps the channel.
Politics is now, unfortunately, infecting lots of stuff that you would have thought previously was a matter of sort of medical practice. So what Yelp did was it posted a notice on these centers which, advertise against abortion, but they don't tell you that they're anti-abortion. That is, they say, interested in abortion, come here. The Yelp posted a notice on the business pages of those places saying, these centers typically provide limited medical services and may not have licensed medical professionals on site. And Ken Paxton sued Yelp, saying that was a deceptive label. Although I suspect the chances of proving that are not all that high. The point is to harass Yelp and to make it not distinguish these. So interestingly enough, this isn't the label Yelp uses anymore. Yelp now says these places don't provide abortions.
So there are obviously two schools of thought here. There's the Yelp school of thought, and then there's the Ken Paxton school of thought. In the Yelp school of thought, the argument is that I'm simply labeling it as they do not tend to perform adoption, which is by definition truthful and not misleading, I would argue. But can something that's truthful and not misleading still be disparaging and therefore meet Ken Paxton's definition?
So it has to be untruthful to be disparaging. 60 years ago, we switched over to a model that says, no, truth by definition can't be disparaging. Right. At least if you're saying, what the facts are, and then people might draw conclusions from that. But disparagement is inherently linked to falsity in our current system.
Now that you've raised the idea of disparaging, maybe this isn't as relevant, but I'm going to raise it anyways. There is a current lawsuit being considered in California. And in the lawsuit, doctors in nursing have come out and said they want the right to call themselves doctors, just like MDs and DOs do. Is this the same issue being discussed all over again, i.e., when is something truthful and not misleading, or is this counter-speech argument necessary to have that conversation?
I think it is fundamentally the same question, which is, in some sense, who gets to decide? The Yelp situation is Yelp saying, these provide limited medical services. And Ken Paxton says, no, they provide all the medical services you need to have a baby. And I suspect that's not actually true either. But the question is, what does limited medical services mean?
Right.
And, does it have a meaning that is capable of being falsified? And then doctor, I think, is the same thing. But the question here is, do you get to push the boundaries?
But let's assume arguendo that the nurses win this argument, right? In that scenario, does that mean that you and I, as lawyers, can now hold ourselves out as doctors? Because in our cases, we often have legal rules that prevent us from saying exactly that. But is that at that point a void argument?
So I would say it would certainly be possible for the next thing to be for us to say, Juris Doctor means doctor. So sure, I can call myself a doctor. Attorney regulation has existed for a long time, and there are First Amendment challenges to it on occasion, and increasingly, but not uniformly, they succeed. So it really is the same question. Is it like is it going to mislead a reasonable consumer? Is there any way to clarify in a way that a consumer would pay attention to? And I think, unfortunately, the answer to the second question is probably no. So you probably have the choice of saying, no, you can't do it at all, or you can do it.
So you don't see the argument. I think one of the ways hospitals have been dealing with this situation is by saying, you know what, we'll allow everyone with a doctorate to call themselves doctor, but then you have to clarify doctorate in what. So I have a doctorate in pharmacy. I'm allowed to say Darshan Kulkarni, PharmD, or Dr. Darshan Kulkarni, pharmacy department. That way it's clear where I'm coming from. On the other hand, I don't know how useful that level of transparency would be.
Exactly. So my expectation would be that if the suit succeeds, it will be with the proviso that they have to say doctor of what. And I'm just telling you that from what we know about reasonable consumers is that qualification will not hit.
Takes us to food advertising and this idea of when can something be called milk? When is oat milk milk? And I forget, I think it was either a joke or a politician who said it, but if you can't milk the oat, it doesn't count as milk.
Here's the problem, and the regulator knows the problem, but can't seem to convince courts that there's a solution, which is people know quite well that oat milk is not dairy milk. They do not know that oat milk is nutritionally different from dairy milk. And there are some really tragic stories of vegan parents, trying to do the best that they can for their children, really putting them in horrible nutritional situations. So should we just prohibit the use of oat milk so that false equivalence won't occur? So far, the courts have said, no, that's not a solution because consumers understand it's not dairy milk. And courts have sort of brushed off the nutritional questions.
When it then makes sense, again, going back to the same legal fiction we talked about a few seconds ago, we said doctor of nursing, doctor of pharmacy. Would you then say oat milk, not a dairy product?
This is the problem of sort of one idea at most, right? Vague statements like nutritionally different do not get consumers to investigate. It's sort of like talk to your doctor. Like maybe you will,
Right.
but really what that's shorthand for is, there's a lot of extra stuff here that we're not bothering to tell you and that you probably don't need to worry about, right?
Going back to this whole idea of amorphous terms that aren't well defined, we also had a situation like that with SlimFast. And we were talking about them using the term clinically proven. So do you want to talk a little bit about that case?
The reference to clinically proven is to the SlimFast plan, but the clinical studies on which they rely were not based on the SlimFast licensed foods that you can get in the grocery store. So the plaintiffs in this case challenge putting clinically proven on the box, because the stuff in the box is not clinically proven.
SlimFast's argument would be, we're saying that the plan is compliant. How else could we advertise the plan?
Consumer point is, yes, on the front of the box, it says clinically proven, lose weight and keep it off. And it doesn't make any reference to the plan on the front of the box. Only on the back does it say it's the SlimFast plan that's clinically proven. And, you don't really need to buy the chocolate peanut butter cups to do the SlimFast plan, nor were the chocolate peanut butter cups, tested as part of the clinical studies.
Now, is this primarily being done at a court level where individuals are suing companies, or are you seeing a lot of this also at the BBB, NARB, NAD level?
A great question, because part of it is about freedom to operate. So mostly competitors prefer freedom to operate in this space. So they're much less likely to bring this type of challenge. That being said, it's not impossible that you get a competitor making similar claims, or a regulator, and most of the regulation or most of the lawsuits about milk, for example, are from the regulators. or against the regulators as they try and impose a standard of identity for milk.
The FTC, as you know, has come out and started talking a little bit about quote-unquote dark patterns, and they're talking about how they have concerns about dark patterns. Could you talk a little bit about what they are and how they affect us, normal human beings?
Right. So a dark pattern is basically something that affects your judgment in a way that helps the marketer and hurts you without you knowing it. So the easy example is something like hiding terms and conditions behind a link. And it's just, we have decision fatigue. So we just don't bother to go and investigate the terms and conditions, no matter how onerous they are. Or pre-checked boxes saying, sign me up for your mailing list, or sign me up for a recurring charge of $9.99 a month for this, additional product. And there have been various attempts to regulate them, but, marketer creativity is infinite because marketers are people. And so the dark patterns concept is designed to capture the idea that people will come up with new ways of kind of distracting us, or, making it so that we check a box that, if we'd really understood, we wouldn't have checked, and so on.
As the FTC go back and enforce these rules, because I know that you said there are laws that are coming out, the FTC is looking at it. Are these enforceable as they stand, or is it more in the theoretical stage?
With the auto renewal, at least the ease of cancellation is now somewhat better because of a law passed that at least purports to require explicit consent for any auto renewal. And also requires a relatively easy cancellation mechanism. So it doesn't help you out with the refund.
So is this a constant issue? And how should, I'm not saying SlimFast does this, but I imagine a bunch of dietary weight loss companies and the like are involved in these types of issues. A lot of these product advertisement companies that are selling you subscriptions to drugs are probably doing similar issues. Could you talk us through that concept?
Marketers have an inherent, completely understandable incentive to try and keep you as a customer. And the issue we face is there are legitimate things. So, when you call Comcast, you say, I want to switch. If they offer you, a half price year, right, that's probably on balance good. So we don't want to ban, trying to keep the customer. On the other hand, right, you should not have to take an hour to cancel if you are cancellation minded.
I've always thought of Europe as very, very pro-consumer, while I think the U.S. tends to be very pro-corporation, for lack of a better term. And on one hand, I love the idea of saying, are you acting in good faith? However, as a attorney who has to advise these companies, I'm going, what does that actually mean? How do I advise you on, is this good faith?
And that's because, we have regulators like Ken Paxton, whose assessment of good faith I have no faith in whatsoever. In the U.S., we tend to say, okay, we're going to have objective metrics, and that might be the best we can do. So, for example, you have to, if you could sign up by this method, you have to be able to cancel by this method, right? And because they make it super easy to sign up, in theory, that should make it super easy to cancel. So there should be no more of this. You have to call us or send us a separate email.
Rebecca, we can keep going as always, but you're fascinating, and thank you so much for coming on.
Well, thank you for having me.
For assistance with your advertising compliance needs, feel free to contact us at darshan@kulkarnilawfirm.com.